carrying in the appeal starring Weald Basin Limited and another against Bocardo.
Mr. Gaunt, I think it's you to begin, is that right?
It is, my lord. My lords, I appear on behalf of the appellant in this matter, and that is Bocardo SA, together with my learned friend Mr. Michael Belloff, Queen's Counsel, and my learned friend Mr. Edward Peters. And for the respondent, Star Energy, my learned friend Mr. Michael Driscoll appears, together with my learned friend Mr. Kieran Keller. The Secretary of State for Energy and Climate Change has submitted a case by way of intervening, but is not represented and is not here. My lords, I and Mr. Peters appeared at the trial and in the Court of Appeal, and then friends Mr. Driscoll and Mr. Keller appeared in the Court of Appeal. My lords, I have provided your lordships, I hope your lordships will find it in front of you, with a piece of paper setting out the order of my submissions in order to keep myself on the straight and narrow and give your lordships an indication of where I'm going. I hope that will be helpful. Let me start with the issues, which I'm sure your lordships will have already mastered. This is a case in which Bocardo claims damages for trespass on account of the fact that, unbeknownst to Bocardo and without Bocardo's consent, wells for the extraction of oil were bored beneath their land and subsequently used for some 15 years before this action was brought for the extraction of oil. The claim raises a number of issues. They can be categorized into two groups, the trespass issues and the damages issues. The damages issues are the subject of my appeal, since both the judge and the Court of Appeal found the trespass issues in my favour. But the trespass issues include three, really, which it's quite a good thing to separate out. There's whether the incursion was a trespass at all, and learned friends say it was not. Even if it was, whether I can sue in trespass, whether I have a cause of action in trespass for the drilling of the wells at depth beneath my land. And the third point is whether the incursion was authorised by statute. Now, as to the first of those 2 points, they will be dealt with by my learned friend Mr. Belloff after I've made my submissions.
Is he effectively a respondent on the trespass issue?
Yes.
And so is it intended that he address us before the respondents address us?
Well, my lords, we thought, yes, it is intended, unless your lordships think that's inconvenient. We thought it was simpler we know what the other side's case is. They've set it out in their printed case, which indeed responds to ours. So we thought it would be more convenient for your lordships if we, as it were, spread out our wares first, then handed over to my own friend Mr. Driscoll to deal with his, and then replied to him. If your lordships would like a slightly more boxing and coxing arrangement, we can of course do that, but that's how we envisage proceeding.
And Mr. Driscoll, you're prepared to proceed on that basis, I take it?
Yes.
Right. Very well. Well, we'll just go ahead as you plan.
My lord, thank you. The judge, as I've said, held that there was an actionable trespass and awarded £621,000 by way of damages up to the end of 2007, and made an order which regulated payment for future trespass in lieu of injunction.
You will speak up a little, will you, Mr.
My lord, I will. I'm so sorry. Thank you for pointing that out. And the Court of Appeal reduced that award to £1,000 to cover both past and future trespass. The damages question involves examining the effect of the applicable statutes which the oil company could have invoked to obtain the necessary rights, but did not in fact invoke. And our case is that, although it is appropriate to look at those statutes and to look at the question of damages against the background of those statutes, they do ultimately, when you analyse them correctly, make no difference to what the common law measure of damages would have been. Now, my lord, before embarking on my legal submissions, I thought it would be helpful to your lordships to say something about the cause of all this trouble, and that is the practice of deviated drilling.
We have read quite a bit of the background, of course, and we have the map which helps us to understand the geography a bit.
Yes, indeed. You do have the map at the back of the statement of facts, I'm grateful, which shows the location of the three wells, the two wells for extraction of oil, and the one well for the pumping in of water to accelerate the extraction of the oil.
And am I right in understanding that there is no need to drill any more? I mean, the drilling has reached the reservoir of oil.
Yes.
And it's not as if you've got to drill further down to get more oil out or drill other wells to extract it. This is the necessary ancillary right, as it were, has been asserted to the extent of.
Yes, my lord, that is correct. Something I didn't appreciate when I first came to this case, and which one needs to appreciate, is the effect of oil being lighter than water. You don't drill deep into the reservoir for oil, you drill into the top of the reservoir. And what you have to do is hit the apex.
Yes, this is the problem in the Gulf of Mexico, isn't it? The stuff gushing out.
It is related to that problem in that oil flows. But the point is with an oil field that once you've discovered that there is oil, you have to look for the apex of the field. And that's one of the points of drilling your exploratory wells. If you can hit the apex of the field, you will get the maximum amount of oil out of the field. You will leave behind the minimum amount of what is called attic oil. The point is that the water in the ground pushes the oil upwards, and the nearer you can hit the apex, the more oil you can extract. And that was the reason for drilling the deviated well under Bocardo's land. Star Energy owned a small site where they had their wellhead right next to the boundary of Bocardo's land, which your lordships can see on the plan.
Coney Hill.
Coney Hill, that was the name of it. And from that, they drilled wells in several directions. The wells they drilled in the other direction, I don't think achieved anything. The well they drilled, PW5, under Bocardo's land, hit the apex of the oil field, that part of the oil field. And indeed, if your lordships look at the plan at the back of the statement of facts, you will see contour lines on it, which show that the point at which PW5 arrived was less deep than other parts of the oil field. You'll see the contour lines coming up, showing the depth of the oil. This is illustrated, and was illustrated to the judge. I don't know whether your lordships have seen this, in the expert's report of Mr. Aaron, which you can find at Appendix 2. And if I can invite your lordships just to look at that for a moment. On page 152 of Appendix 2, there is a plan. Now, this is not the plan of where the oils were drilled. What Mr. Aaron was trying to do here was to examine the question of whether the oil wells had to go, as a matter of necessity, under Bocardo's land. And he was investigating what would happen if you put them somewhere else. So he moved the wellhead a bit to the south, and he drilled them so that they missed Bocardo's boundary, and then he tried to work out what would happen. And he came to the conclusion that they wouldn't get nearly as much oil out, and that location was suboptimal. And he explains all this by reference to some diagrams on the following page.
Yeah, his wellhead seems to be in a different place. His drilling point is different.
His drilling point is different. What he was trying to do is to say, if Star were to move their wellhead, because Bocardo were being difficult, if they were to move their wellhead onto land which in fact they didn't own but would have had to acquire, and drill their wells so as to miss Bocardo's land, what would have happened? And his conclusion was they'd have got much less oil. And he explains this on the following pages by reference to some diagrams, which are quite a graphic illustration. The diagram at the top of page 154 shows the actual location of PW5 in the top of the oil field, and the suboptimal location lower down. And then in the following diagrams, he shows the water level, the blue, rising until it hits the bottom of the hypothetical well, and he shows graphically that the well waters out, as it is called, much earlier if you don't hit the apex of the oil field.
So you're left with the green oil, which is not extractable.
That's right. On page 156, you have a very small amount of green oil left if you hit the optimal point, but on the earlier pages you can see you have a much larger amount of green oil left if you don't hit the optimal point. The well waters out earlier.
Yes?
And he concludes at paragraph 35 of his report, which is on the bottom of page 154, this lower overall recovery from the field would have been of concern to the DTI. The DTI policy is to maximise the economic recovery of oil in approving a development plan. I note this obligation is also mentioned in the statement of Mr. Horgan, which you also have. It's my view that this suboptimal plan would not have been allowed by the DTI, and that the only acceptable approach was the subsurface location at the crest of the structure on the Oxted estate. Now, that was not a controversial view at all. It was also the view of the oil expert called by Starr, and if your lordships would be kind enough just to turn on in the same bundle to page 187.
187.
187.
I mean, is all this designed to show how valuable it was to these oil extractors to go to deviate under your lat? Is that the
Yes,
point?
it is, my lord.
Yeah,
That is the
yeah.
point.
I just see where we were going.
Yes, that's absolutely right. It was a necessary part of our case, because if they could have gone somewhere else just as easily, they wouldn't have wanted to come under our land. And that would obviously have played a part in any negotiation that had taken place at the time. Mr. Wright says that he was asked various questions, of which I just direct your attention, if I may, to two at the top of page 187, questions C and D. Why were the well paths of those wells drilled as they were? Could they have been drilled differently? And if so, in which direction? So he was asked that. And his answers are at paragraphs 32 to 34. On page 192, he says the department require operators to optimally develop the field in terms of maximising the economic recovery of oil and gas. This is laid out in guidelines, and it's a requirement for the approval of Annex B, that's the development plan, prior to production of hydrocarbons from any field. PW5 was drilled as a deviated well from the Coney Hill site to target the structurally highest area in the eastern part of the field, as mapped on the seismic data. A well to this subsurface location was required to maximise the economic recovery of oil from the eastern part of the Palmer's Wood oil field. 34, if the operator on behalf of the licence holders had decided not to target the structurally high eastern part of the Palmer's Wood field, it's unlikely the recovery from this part of the oil field would have been maximised. An attic area would have been left, and so on. And at paragraph 39, he says it's very unlikely that Palmer's Wood deviated wells drilled from the Coney Hill site could have been drilled to different subsurface locations without compromising their objectives of maximising economic oil recovery from the eastern part of the field. It's possible slightly different well tracks could have been selected, but it's likely that the same number of wells to essentially the same targets would have been drilled. And indeed, when they came to agree a statement, which is at page 196 onwards, if I could ask your lordships to look at page, my lords, 196. This table shows the degree of agreement between the technical experts, which is very considerable. Item 3 on page 196, requirement for deviated drilling. Mr. Aaron says he accepts that PW5 was a necessary part of development to avoid attic oil, and Mr. Wright agreed that it required access for PW5, PW8 and PW9. And slightly more, perhaps clearly, at item 11 and item 12 on page 198, PW5 location required at the chosen location to maximise production. Both experts agreed that. Item 12, recovery of structurally high part of field at PW5 location. Annex B, that's the development plan, could have been rejected without this. Both parties agreed that. Now, my lords, having said that, I should, because it goes to one of the points taken by my learned friend, explain one other thing. During the course of the trial, Mr. Wright produced a supplemental report, which you do not have in your bundles, positing an alternative target. The alternative target resulted in a lower loss of oil than Mr. Aaron's alternative. But the alternative target was not, and this is important, under land owned by Starr. It wasn't under Bocardo's land, it was under land owned by an adjoining landowner. It wasn't a vertical well, it was another deviated well, and it would have required the acquisition of rights from the landowner of the other land. So the choice would have been go to the suboptimal location or go to the optimal location. The DTI prefers the optimal location, and if you go to the optimal location, you get more oil. So that's where you want to go, and that's under Bocardo's land.
I didn't quite. So there's an alternative target. Did you say with less loss of oil?
Less loss of oil than Mr. Aaron's alternative target.
Oh, I see. Yes.
But more loss of oil than
Bocardo.
under Bocardo.
Right, I follow. Yeah. Yeah.
Sorry to take your lordship to this detail at the moment, but it does go to one of my learned friend's points. And the judge said, having heard the experts, that he thought the DTI would have been likely to approve a development plan for the alternative location if Bocardo had proved unreasonable. Now, that's not what the experts were saying in their reports, but that's what the judge found, so I have to face up to that. Of course, the alternative location's all very well, but it never came to that because Bocardo never asked. Starr never asked. Bocardo was never asked for permission to drill under its land, and Starr never considered drilling anywhere else. They drilled where they thought they'd get most oil. And that fact was concealed from Bocardo, who didn't discover it until 2006. Now, I hope that little explanation of the background to the deviated wells will help.
Yes.
I will move on then to the basis of my claim, which is item 3 in my summary. The claim, as your lordships have seen, both the trial judge and the Court of Appeal held that the retention of the tubing and casing constituting the wells was an actionable trespass. There was some complication at the beginning of the trial because an admission had been made in the defence that the tubing and casing had been put there by the defendant and that the defendant had been put there by the defendant in 1990. And in fact, the defendant, the party who was being sued, did not become the oil operator and the licensee until 1994. And at the beginning of the trial, the trial judge gave permission for the defence to be amended. So the present defendant was not a trespasser before 1994. In fact, none of that ultimately mattered because my claim was held to be statute barred before 2000. So my claim is only in respect to the period from 2000 to 2007, in effect, and onwards.
So statute barred until 2000?
Yes, it's statute barred before July 2000.
22nd July.
I'm sorry, my lord.
22nd of July.
That's absolutely right.
I was only.
And it's a continuing trespass. So
It's a continuing
casing
trespass.
and the
It's a
tubing
continuing
remain.
trespass because the piping is still there and is being used for the purpose of extracting oil. Now, That raises, of course, the question of what is the proper measure of damages for that trespass. We have always accepted, right from the beginning, that no damage has been caused to our land. We haven't suffered any inconvenience. We simply claim damages on what is often called the user basis or the way-leave basis, sometimes the negotiating basis. And it is accepted by Star that if this basis is applicable, which they say it isn't, the measure is what reasonable persons in the position of the parties would have negotiated for a license to get access to the oil. And it's common ground that any such negotiation would have taken place against the background of the relevant statutes. Now, I emphasise that Star say that basis is not applicable for a number of reasons which I will come to, but if it's applicable, it is accepted that that is the measure of damages under the way-leave or user basis. And that factor then requires us to analyse the terms of the relevant statutes, and particularly the provisions as to payment under those statutes for the rights which we say Star needed and could have applied for, but did not. So we are imagining a negotiation at a time when they needed those rights, could have applied for them if they could not succeed in negotiation with us to acquire them, and would then have had to go to court and get them, which they could have done under the relevant statutes. Now, before I take your lordships through those statutes, which I will do in a moment, could I just make a few observations which may strike your lordships as rather trite about land value, but they go to the heart of my submissions. The first of these is that the value of land, or a right over land, which is what we're concerned with here, is not necessarily confined to the value of the land for its existing use, or any use to which the current owner intends to put it. Also material are all and any potential uses which the land may have. So potential is part of the value of land.
And that applies below the surface as well as on the surface, does it?
There is no reason why it should not. If, as we submit on our side, ownership of the surface carries with it ownership of the land beneath the surface, then the principle that the potentiality of land is part of its value will mean that the potentiality of the land below the surface is as much part of its value as the potentiality of the land on the surface.
Is there any evidence that it has potential in a way that's being impeded by the existing casing and tubing?
No. The potential I'm talking about is the potential, as I will explain in a moment, to say to a party wishing to pass through it, you can't unless you pay me a fee.
You say it's a potential to have a deviated well, put through it. Is it?
Yes, it is. It is.
It's like the ransom strip.
It's like the ransom
It
strip.
doesn't matter whether the ransom strip's on the top of the land or
Underneath it.
underneath the land.
No. Well, your lordship is absolutely there. It's gone straight to it. I mean, this situation, just to follow up my Lord Clerk's observation, is quite a simple one. Star owns the wellhead, Coney Hill, the site where the wellhead is. Star owns the oil, in effect, because they have a petroleum licence from the Crown, which enables them to extract the oil and sell it. So it's like a party who owns a piece of land here, a piece of land there. To get from this land to that land, he's got to go through some land in the middle. That's the situation.
Yeah,
and
so
You can't get the oil without it.
Can't
they
get
will
it.
pay a price for it.
That's right.
So it's the kind of situation that could arise on the surface, where you simply have to have a way-leave because the land you want to use is landlocked otherwise.
That's right.
So there's no question in this case, although there might in some case be the problem of minerals below the tubing and pipes and so on, which you're impeded from getting at because somebody has already got this stuff in between. Well, that doesn't happen in this case, but it might in some.
There is certainly no evidence that there is another mineral beneath the oil deposit, and it was no part of my case that I was suffering loss because I was being impeded from getting to that mineral. Of course, for all we know, there might be another mineral below the oil deposit, which might, as technology develops, be recoverable at some time in the future. That is a point which doesn't go to this part of the case, but may go to the question of whether land ownership goes down deep.
Yes.
And my learned friend, Mr. Beloff, will no doubt address you about that. But to answer your Lordship's question, no, there's no question of impeding access to something else. I'm not claiming that I've lost because I'm being stopped by the presence of the wells getting to some other valuable mineral. Now, the second point I was going to make is Lord Clark's point. Land with little intrinsic value can acquire special value because of its location, which makes it attractive to a special purchaser, or may make it even vital to the exploitation of other land, the example being a ransom strip. The situation needn't be quite as extreme as the case of a ransom strip which gives access, which can't be obtained from anywhere else. One can have a situation where, for example, the development of other land, because planning conditions apply, require improvements to the highway or something of that kind, and land which is necessary to effect those improvements is necessary to facilitate a profitable development of other land, and therefore requires a special value. But that is perhaps only an example of the ransom strip in another context. But my point is that land which has little value, perhaps no value otherwise, may acquire value because of its location. And the reason it does in that example is that it enables the landowner to stop somebody doing something.
It enables him to do what?
To stop somebody, to stop another party doing something which the other party wants to do. Another example of this is crane oversailing rights.
Is what?
Crane oversailing rights. If I own land, perhaps in the city, and my neighbour wishes to develop it by building a new and very tall office block and uses one of those tower cranes, he cannot jib his crane across my land unless he gets a licence, because that would be a trespass. And so I am in a position to say no unless you pay me a fee. Now, the crane doesn't inconvenience me. It doesn't cause me any loss. It doesn't damage the building on my property. But I'm still entitled, nevertheless, to charge him a fee because otherwise he can't do what he wants to do because I'm the owner of the land and I can restrain a trespass. What is true above land is true below land. There are cases where there are mine workings under land which have been worked out so that there are tunnels and passages. And an adjoining owner wishes to use the landowner's tunnels and passages to extract a mineral, such as coal, normally, from his own land or neighbouring land. So he wishes to have a way leave to go through the underground passages to get at the coal and to extract it. Now, it doesn't matter to the landowner whether somebody goes through his passages or not. It doesn't make any difference to him. It doesn't cause him any loss, doesn't cause him any inconvenience. But he can nonetheless charge a way leave rent, because otherwise what the mineral operator would be doing would be a trespass. He could be prevented from doing it, and the ownership of the land gives the landowner a bargaining position so that he can charge. So the point is that a landowner may be in a position which gives him a bargaining position if the circumstances are right. And that may have substantial value. And if that bargaining position is taken away by statute, one would expect, prima facie, that the landowner should receive compensation for that deprivation.
You mean if a statute gives, as it were, an ancillary right to the wellhead owner to carry on an operation underneath the landowner's land?
Yes.
That should be paid for in a way that reflects the point you've been making, is that
Yes. That is precisely the point. And if you find in a statute a provision which says that the landowner is to be compensated by reference to the bargain which he would otherwise have made, then one would expect to find that compensation taking into account the loss of bargaining position. Now, this is not a principle confined to property. Let me take two other examples. A restrictive covenant. Now, a restrictive covenant is a property right, of course, but it arises by contract. And a restrictive covenant may give you, as a landowner, a right to stop somebody doing something he wants to do on his own land. Now, breach of the covenant may cause absolutely no loss to the covenantee. Indeed, such covenants are often taken in circumstances where they will not cause loss to the covenantee, breach will not cause loss to the covenantee. They're often taken in order that the covenantee selling land may at a future date participate in the profits of the development of the land which he has sold. So he takes a covenant not to develop, which means that if the purchaser wishes to develop at a later stage, he has to come back to the covenantee and say, please release me from my covenant. And of course, the covenantee can charge a price for that release. And if, as sometimes happens, the covenant is broken behind the back of the covenantee, and he finds that a development has taken place, it may be that the court will not grant an injunction to knock the buildings down, taking the view that that's a terrible waste. But in those circumstances, the court will compensate the covenantee by giving him damages equivalent to what reasonable parties would have agreed for the release. And that's exactly what happened in the famous Rootham Park case, which involved the breach of a restrictive covenant. But the restrictive covenant is a proprietary right, but the same principle just applies in ordinary contract. Let's take the case of a lockout agreement, a case where one party has promised not to approach or negotiate with a third party and then does so in breach of that promise. It may be that the promisee has suffered absolutely no loss because his negotiations would have failed, or perhaps already had failed, before the breach. But if he could have charged a fee for the release of the promisor's promise, then he can recover damages equal to the price of that release. And that's exactly what happened in the case of Pell Frischman, where my Lord Walker delivered their judgment to the Privy Council, which I will refer to in a moment. Now, my point here, perhaps over-elaborated, is that the power to permit an act which you can otherwise prevent creates a bargaining position which has a value.
And there's nothing improper, you would say, about making use of that.
Nothing improper
position.
at all about making use of that bargaining position. And this is really at the nub of the criticism I make of the decision of the Court of Appeal.
I mean, the bargaining position isn't quite as strong as it would be here, is it? Because you do know that at the end of the day, if you hold out for too much, they go to court and get something instead from the court.
My Lord, that's absolutely right. But as we shall see in a moment when we come to the statutes, what the statute requires one to do is assume, in my submission at any rate, a bargain apart from the Act, not a bargain against the background of the Act, but a bargain apart from the Act. What the Act says is that compensation must be awarded on the basis of a fair and reasonable deal between a willing grantor and a willing grantee. So that's not a constrained or forced deal, that is a voluntary deal. And I'll make my submissions on that in a moment.
So you say the number's the same?
I say the number's the same.
The measure of damages is exactly the same amount as it would have cost them if they'd gone to the court?
Well, actually what I say, my lord, is it's at least as much as if they'd gone to the court. Because if they'd gone to the court, there would have been delay, there would have been expense, there would have been uncertainty, and against the background of the Act, if anything, the oil operator would be generous, because he would wish to avoid having to go to court, which could take up to 2 years. We'll see what the procedure is in a moment. It would cost him a lot of money, and it might hold him up. What one might call the hassle factor. But yes, so essentially I say I'm no worse off because of the Act than I would have been at common law. And if I might just ask your lordships to look at one paragraph of the judgment of the Court of Appeal at this stage. We have that in Appendix 1, which is at the back of the core volume. And it's paragraph 112 that I wanted your lordships to see in the judgment of Lord Justice Akins. It's on page 39 of the tab behind of Appendix 1. Paragraph 112, where Lord Justice Akins says, the question is, what would be a fair and reasonable compensation or consideration between a willing grantor and a willing grantee for the right to drill 3 pipelines at those depths, which would not disturb or detract from Bocardo's use of the land 1 iota? Put in the terms that Mr. Justice Peter Gibson expressed it in BP and Ryder, what is the value that Bocardo would have lost by the grant to Star of this right? The straightforward answer is nothing, because the right to drill pipes at those depths is worthless to Bocardo unless it could be used to exploit the petroleum licence, which Bocardo cannot. Now, I say that's not right.
Well, it's the wrong question.
I say it's the wrong answer.
Wrong answer.
What is the value Bocardo would have lost? They've lost their bargaining position. There's an element of value here, which is Bocardo's bargaining position, which has not been reflected by the judgment of the Court of Appeal. It's the only element of value, actually, because a small tube, 12 inches in diameter, 3,000 feet under your land, is of no value to you at all, apart from the right to stop somebody else putting it there if he wants to.
So the last sentence you say is misconceived then?
I do.
Because, well, it's certainly true that Bocardo can't exploit the petroleum licence.
That's absolutely
it can
right.
stop the other party from doing so.
That's absolutely right.
In a way, it's the wrong question in the sense, on your case, you shouldn't really add, which would not disturb or detract from Bocardo's use of the land 1 iota. There might be a relevant consideration in deciding what the loss was, but it distorts the question.
Yes. I accept, of course, that it does not disturb my use of my land. It does not detract from my use of my land. What it does do is it makes use of my land in a way which I'm entitled to prevent.
But this is quite near the end of the judgment, and the Lord Justice Akins already decided that Mr. Justice Peter Gibson was right in Ryder, hasn't he?
Yes, he has.
So I think your case is that it's both the wrong question and the wrong answer.
Well, my lord, yes, it is. It is. That's right. I do, of course, admit that in the earlier part, where compulsory purchase principles and point good and so on are deployed, I take issue with Lord Justice Akins about that. But when we come to asking that question, what has Bocardo lost? Of course, the answer is dictated by what Lord Justice Akins has held earlier in the judgment, because he's held that you have to ignore the exploitation of the oil field.
Exactly.
But if you ignore that, I have nothing. The
antecedent point is whether, in fact, you have a bargaining position. The Court of Appeal says you don't.
The Court of Appeal says I don't, yes. And I say that is completely contrary to what Section 8.2 of the Act says, and we will look at that in just a moment. So, my Lords, having identified the bargaining position as the central issue in the case, I can take, I think, the question of damages on the Wayleave or Rootham Park basis quite quickly, because I don't think this is a controversial part of our case. But if I could go back to our case, we discuss damages on the user basis at paragraphs 5 to 11. And
So we're looking at your printed case, are you?
at my printed case, if your Lordship would be so kind. We explain there that this, the fact that the courts will award damages on the so-called user basis derives actually from mining cases, from Wayleave cases, involving carrying coal through somebody else's mine. And it then came to be applied to the surface of land in the Whitwan case, which is referred to in paragraph 7 of our case. And it received a fairly recent recognition in the famous case of the Attorney General and Blake, the case about the traitor Blake, where Lord Nichols considered the various bases on which damages could be awarded, and discussed damages for trespass to land in the passage which I've set out at paragraph 8 of the case. The point about that citation is that damages are measured by the benefit received by the trespasser, namely by his use of the land. And as Lordship says, the same principle is applied where the wrong consists of use of another's land for depositing waste, or by using a path across the land, or using passages in an underground mine. In this type of case, the damages recoverable will be, in short, the price a reasonable person would pay for the right of user. Now, that is not an account of the profits, of course. That is a reasonable payment for the right of user, and a reasonable payment for the right of user takes into account, no doubt, the value to the trespasser, to the defendant. But it won't be the whole of the value to him.
It's like mean profits.
Yes, it's like mean profits. It's very like mean profits.
Well, is it really? Mean profits is actually what it's worth to the, without more, what it's worth to the purchaser. I mean, is that really what you say? You can actually extract, you can actually reach the point where you're asking, well now at this point, if they had no option but to use these wayleaves or these deviated shafts, would Star simply say, well, it's not worth our bothering to exploit it?
Well, if they said that, they wouldn't do a deal. And if there isn't a deal, then I get no money.
But you say you can take them right up to that point, do you? At the point at which they cease to?
I can take them towards that point.
How far?
Well, what the statute limits me in two ways, as we shall see. It requires that the price that I agree with them shall be a fair and reasonable price, and it makes the assumption that both parties are willing to deal, that neither party refuses, is reluctant, will not do a deal. They both want to make a deal. It's quite a common basis for the assessment of compensation or assessment of rent in various contexts, that both parties are willing parties. One willing to pay what it's worth his while to pay, the other willing to grant the right at a reasonable price. That is both what the section requires and it's what the common law requires when assessing damages for trespass. And that has been held on many occasions. The Lordships say, is it like mean profits? And the answer is absolutely yes. There's a case here, referred to in footnote 7 of our case, Swordheath Properties and Tabbit, a case of which I'm not particularly proud because I was the cause of it. As a very inexperienced counsel in the West London County Court in the 1970s, I elicited from the director of a property company the information that if he got possession of the land that my client was occupying, he wouldn't let it, because in those days the last thing property companies wanted to do was to let properties because of the Rent Acts. He'd keep it empty until the market rose and he could sell it. I then submitted to the county court judge, who accepted this submission, unfortunately, that in the circumstances there were no damages because there was no loss. The case goes to the Court of Appeal, and the Court of Appeal said that's completely wrong. The fact that there was no loss doesn't matter. What happens is that you have to pay for the enjoyment of the land which you've been occupying.
Which case was that?
That's Swordheath Properties and Tabbit. It's referred to in footnote 7. And it was applied by the Privy Council in the other case in that footnote, the Inverugi Investments case.
I see.
In fact, perhaps I might just take your lordships very briefly to the Inverugi case. It's in bundle 5 of the authorities' bundles. At tab 59. It was a curious case involving a hotel in Grand Bahama containing 30 apartments. And for curious reasons, the defendant was held to have been a trespasser in this hotel for over 15 years. And there was a claim for damages for trespass on this basis, on the user basis. And the question was, could one take into account the fact that for most of that time, a lot of the apartments had been empty, and that the operator, the trespasser, had been unable to let them because the occupancy was less than 100%. And the answer was no. The answer was you've got to pay the going rate for letting to tour operators of all 30 apartments. And the principles are set out at page 717G, or F, it starts, 717F. Before starting their own conclusions on the facts, their lordship should say a brief word on the law. The cases to which they've already referred establish beyond any doubt that a person who lets out goods on hire, or the landlord of residential property, can recover damages from a trespasser who's wrongfully used his property, whether or not he can show that he would have let the property to anybody else, and whether or not he would have used the property himself. The point is well expressed by Lord Justice McGaw in Swordheath and Tabbit. He said, "It appears to me to be clear, both as a matter of principle and of authority, that in a case of this sort, the plaintiff, when he's established the defendant has remained on as a trespasser in residential property, is entitled, without bringing evidence that he could or would have let the property to someone else in the absence of the trespassing defendant, to have as damages for the trespass the value of the property as it would fairly be calculated. And in the absence of anything special in the particular case, it would be the ordinary letting value of the property that would determine the amount of damages." And then there's a reference to some famous examples given in the old authorities. As the Earl of Halsbury, the Lord Chancellor, pointed out in the Mediana, it's no answer for a wrongdoer who has deprived the plaintiff of his chair to point out that he does not usually sit in it, or that he has plenty of other chairs in the room. There's another famous example of a horse which is ridden without permission. You can't say, well, I've done you a favour because I've given you a horse some exercise and it's better for it. You have to pay the higher charge for using the horse. I suppose a more modern example might be borrowing somebody else's car. And Lord Lloyd in Inverugi goes on to say that Lord Justice Nichols, as he then was in Stoke-on-Trent and Was, called the underlying principles in these cases the user principle. The plaintiff may not have suffered any actual loss by being deprived of the use of his property, but under the user principle he's entitled to recover a reasonable rent for the wrongful use of his property by the trespasser. Similarly, the trespasser may not have derived any actual benefit from the use of the property, but under the user principle he's obliged to pay a reasonable rent for the use which he's enjoyed. The principle need not be characterised as exclusively compensatory or exclusively restitutionary. It combines elements of both.
And a reasonable rent is a rent which should be struck between a willing landlord and a willing tenant, is it?
Yes, the willing grantor and the willing grantee in the case of a right-of-way. And in a landlord and tenant case, the willing landlord and willing tenant. Of course, parties striking a bargain like that will not strike a bargain at the extreme end of the spectrum. They will respect each other's negotiating position. Now, in our case, we go on to refer to the cases on damages in lieu of injunction, which are decided on exactly the same principle. They stem from the famous decision in the Ruton Park case, but there are many examples of the courts awarding damages in lieu of injunction on this negotiating basis, reasonable price between willing grantor and willing grantee. That is recognised again by Lord Nichols in the Blake case. And perhaps I could just ask your lordships to look at one paragraph there. It's Authorities Bundle 3. Tab 29. And it's at page 281G. I've already referred your lordships to an earlier passage in this judgment in which his lordship considered interference with rights of property. That starts on page 278. And on this page, 281, he goes on to deal with damages under Lord Cairns Act. And a little over halfway down the page, just between E and F, there's a sentence that begins thus. Thus, in the same way as damages at common law for violations of a property right may be measured by reference to the benefits wrongfully obtained by a defendant, so under Lord Cairns Act, damages may include damages measured by reference to the benefits likely to be obtained in future by the defendant. This approach has been adopted on many occasions. Examples are given. The measure of damages awarded in this type of case is often analysed as damages for loss of a bargaining opportunity, or, which comes to the same, the price payable for the compulsory acquisition of a right. This analysis is correct. The court's refusal to grant an injunction means that in practice the defendant is thereby permitted to perpetuate the wrongful state of affairs he's brought about, but this analysis takes the matter now under discussion no further forward. A property right has value to the extent only that the court will enforce it or award damages for its infringement. The question under discussion is whether the court will award substantial damages for an infringement where no financial loss flows from the infringement. That's Mr. Blake's memoirs. And moreover, in a suitable case, will assess the damages by reference to the defendant's profit obtained from the infringement. The cases mentioned above show that the courts habitually do that very thing.
But I mean, in Blake itself, I mean, they were stripping him of the entire proceeds of the publishing contract.
They did eventually do that, yes. And that goes further than this principle. That is, in effect, an account of profits. And that is not what I'm asking for.
Exactly. So how does it, I mean...
Well, this passage is building up
I see, this is on the way to a crescendo.
This is on the way to a crescendo, which results in stripping Mr. Blake of all his profits.
But going back to that sentence just at letter H, just above letter H, I mean, you're asserting a property right, which you could have enforced by an injunction. Is that right? You could have stopped them.
Yes, I
coming
could have
through
enforced it by injunction, unless the procedure laid down in the statutes,
Yes.
which we'll come to, had been implemented, which it had not. So I'm saying I could have stopped this, and therefore I should have damages. I accept that the damages must be assessed by reference to a bargain. I accept that the bargain had to be against the background of the Act, but I say that when you look at the Act, it itself predicated a bargain of exactly the same kind that the court hypothesizes when awarding damages on this basis.
If it weren't for the Act, could you obtain an account of the profits?
No, my lord. The cases show this. The unlawful mining cases show this. In cases where somebody inadvertently mines somebody else's minerals, there is an account of the profits.
Sorry, I missed this sentence. What did you say?
I'm sorry. In a case where somebody inadvertently mines somebody else's minerals, he does have to account for the profits. Now, this is not such a case because they're not my minerals. So I can't claim an account of the profits. If you deliberately steal somebody else's minerals, then not only do you have to pay damages equal to the profits, you have to pay damages equal to the value of the minerals at the pit head. So you don't get credit for the cost of extracting the minerals. But none of that law matters here because the minerals aren't mine. I can't complain about the minerals having been extracted. I can only complain about a trespass through my land.
And in the very last sentence you read, will assess the damages by reference to the defendant's profit. That is by reference, looking at it, but absolutely not an account of profits.
Absolutely
Although,
not.
in fact, in this particular case, Attorney General Blake, Lord Nichols was on his way to ending up with an account of profits.
My lord, that's right.
Yeah.
I suppose common sense might take you to that position, might it? If the party who wants to drill under your land is told, well, he's got to account for all the profits, there's no value to him in going ahead with the project, is there?
No, there wouldn't be.
I mean, that just seems silly.
And so I can't possibly go that
So
far.
he's going to say, well, I'm the only person in the world who actually wants to do this. I'll give you some money if you like, but I'm certainly not going to give you all the profits. And the bargain proceeds from that basis, and you begin to beat each other down
Yes.
from that starting point.
My lord, that's absolutely right. And as your lordship will see, that was exactly the basis on which we built up our claim in this case. Mr. Crawford, who was our expert valuer witness here, asked the trial judge to imagine the sort of factors which would enter into the imaginary negotiation. And he wasn't contending for an account of the profits, he wasn't even contending for half the profits. His contention was 25% of the profits, which it was agreed was 12.5% of the value of the oil, as it were, at the pit head, the wellhead, I suppose. The judge awarded us 9%. We accepted, Mr. Crawford accepted, that in the course of that bargaining, many features could be prayed in aid on behalf of the oil operator, which didn't apply to us. I mean, the oil operator had the expertise. We had no expertise. The oil operator was investing large sums of money.
Sorry, I'm having difficulty in hearing you, Mr.
I'm so sorry,
on, sir.
my lord, it's entirely my fault.
Well-
I do have a tendency to drop my voice, I know.
I mean, you're twice as far away as you used to be in Committee Room 1.
Right. Right. My lord, I will try and bear that in mind. My lord, I was saying that Mr. Crawford, our witness, took into account, as your lordships can see if you read his report, a large number of factors that would militate towards our share being much smaller than the oil company's share. And we accept that. That was our evidence, and the judge took that into account. And the judge, in effect, accepted Mr. Crawford's evidence, subject to one interesting point, which is that he felt that the judgment of Mr. Justice Peter Gibson in BP and Ryder would itself have been a feature in the negotiation. And we didn't agree with that. We said you ought to approach this on the basis that the parties get the law right, not get the law wrong, which we said had in fact been the case. But we no longer complain about that. We didn't take that point in the Court of Appeal. We don't take it before your lordships. We're perfectly happy with the 9%. But there was a debate about that at first instance. My Lord, returning, if I may, to paragraph 2, our printed case. At paragraphs 16 and 17, we have given your lordship some examples, some what one might call commercial examples, not property examples, of awards on this basis. The Experience Hendricks case involved licensing masters of recordings, the use of masters of recordings unlawfully, and the damages were a quid pro quo for agreeing to permit the licenses, which in effect had been usurped. And in the World Wildlife Fund case, there was a very similar situation. Perhaps most helpful for this purpose is the decision in the Pell-Frischmann case. That's a decision of the Privy Council. And that was a case in which Pell-Frischmann, the engineering company, was negotiating with the Iranian Oil Corporation and brought in a partner who was used to drilling oil wells, Bow Valley. They extracted from Bow Valley a promise not to approach the Iranian Oil Corporation without Pell-Frischmann's consent. But when negotiations between Pell-Frischmann and the Iranian Oil Company looked as though they were coming to nothing, Bow Valley did approach the National Oil Corporation without Pell-Frischmann's consent. Now, Pell-Frischmann weren't going to lose anything by virtue of that because their negotiations had broken down. But they nevertheless recovered substantial damages, which were substantially increased by the Court of Appeal over the award of the lower courts, because they could have insisted on a payment from Bow Valley to enable Bow Valley to go ahead and negotiate directly with the Iranian Oil Corporation. And the case is perhaps of assistance to your lordships because my Lord Walker reviewed the whole topic of root and park damages in the course of his speech. And it is, I think, the most recent consideration of damages on this basis.
And where do we find it?
My Lords, you will find it at Volume 6, tab 75. It is, in fact, an appeal from a decision which, at first instance, my learned friend, Mr. Beloff, was party to.
In the Court of Appeal, I think.
Oh, in the Court of Appeal. I'm so sorry. In the Court of Appeal. My Lord, the passages that your lordships may find of assistance begin at paragraph 49, referring to root and park damages as they're called. My Lord Walker says it's a negotiation between a willing buyer, the contract breaker, and a willing seller, the party claiming damages, in which the subject matter of the negotiation is the release of the relevant contractual obligation. Both parties are to be assumed to act reasonably. The fact that one or both parties would in practice have refused to make a deal is therefore to be ignored. And then a little bit later on, at paragraph 53, this really relates to the facts of the case. Lord Walker says, by the beginning of July 1997, Pell Frishman had not merely lost exclusivity, but had irretrievably become persona non grata with the National Iranian Oil Corporation. It had nothing to assign to Bow Valley, either in terms of legal rights or in terms of commercial goodwill. Its endorsement carried no weight. It retained contractual rights to prevent Bow Valley entering into direct negotiations with NIOC and from using confidential information for that purpose. But those rights were of a negative nature. They didn't reflect or enhance the value of Pell Frishman's interest in the project because Pell Frishman no longer had any such interest. A willing seller acting reasonably would have recognised that an excessively dog-in-the-manger attitude would be counterproductive. At the same time, Bow Valley and Bakri, as willing buyers acting reasonably, would have accepted that even negative rights must be bought out at a proper price, that unless they were bought out, the project could not proceed at all. Now, I say the present case is like that. Bocardo were in a position to deny Star access to the apex of the oil field. Star, as a willing buyer acting reasonably, would have had to accept that that negative right had to be bought out at a proper price. And unless it was bought out, the project couldn't proceed at all, statute apart, which I'll come to. And the sum properly payable on that basis is what two parties, both willing to do a deal, both acting reasonably, would have agreed as a fair price had negotiations been entered into at the relevant time. Now, staying with Pell Frishman for a moment.
I mean, I'm sorry, how do you even begin to... I know you say it's all a matter of evidence, but how does a valuer start saying, well, what's fair? I mean, what is fair for ransom? I mean, you know, why should they have 9%? Why shouldn't they have either 50% or 0.5%? I mean, how do you begin to do it?
Well, my lord, you have to decide it on the evidence.
Well, I know, but where do the witnesses start from? How do you do it?
Well, they do the sort of exercise which we did in this case at some length. They can start from 50-50 if they like. No doubt one party can start as high as 50-50 and the other party can start as low as 5% or something. They both then urge on each other their various points that deserve to be taken into account. I've suggested some. For example, the oil company will say, we've got the expertise, you haven't got the expertise, you can't do this. They will say, we're going to have to invest £1 million to drill an oil well, you're not investing anything, so we deserve a much bigger chunk. But the landowner will say, you, the oil company, you stand to make £14 million from getting this oil from under our land. You've got to pay us something for it because we can stop you getting it. And there's a process of haggling, or higgling, as some of the cases call it, in which the parties try and reach an agreement. Now, we put forward evidence, quite cogent and, I would suggest, evidence that 12.5% of revenue would be where the deal was struck. The judge didn't entirely agree with that. He said 9%. But he heard the evidence. He heard Mr. Crawford on our part. He heard Mr. Smith on the part of the other party. And Mr. Smith, as the judge records in his judgment, agreed that apart from the case of BP and Ryder, if you put that on one side, 12.5% would be achievable in this negotiation by Bocardo, or by
In
Bocardo.
some fields, this kind of exercise is carried out in the light of comparative evidence.
Indeed it is.
I mean, you can take valuation for rating, for example, and it's quite
Yes.
commonplace to conduct the kind of exercise that you're contemplating by simply looking at the market,
Yes.
where you find people negotiating, typically willing buyer, willing seller, and striking a bargain which you can then relate to the subjects in hand by some sort of comparative exercise.
Yes.
Now, valuers are used to doing that, and I suppose in rather specialised fields like this, they won't have the comparative evidence, but they can get some idea as to how people in the real world will go about achieving a figure.
Yes. My Lord, we faced a very peculiar situation here. It was agreed there were no comparables. It couldn't be done by comparables because there aren't any.
No.
And the reason there aren't any is that oil companies have apparently taken the view that they don't have to go under the Act to acquire these sort of rights. They're perfectly entitled to drill under other people's land without their permission and without going under the Act. And since oil companies had taken that view, there were no comparables, no deals, no applications to the court. BP and Ryder was about mainly surface rights. It wasn't about drilling rights. And so in the absence of comparables, you have to do something else. Now, that's not an uncommon predicament for valuers, because there are many types of property, of which hotels actually are one, which you can't value by reference to comparables. You have to value it by reference to what's called a profits valuation.
You have a contractor's basis or a revenue basis, don't you? In
Yes,
valuation
indeed, and
law?
that's in rating, yes.
Yes, but it's the same idea. You achieve something in the absence of comparables by an exercise that's recognised in the valuation field.
Yes. Yes, you do. And hotels are one example of a profits-related valuation. Leisure properties such as casinos are also done that way. They're not done by comparables. They're done by looking at what's called the drop and working out what it's worth somebody's while to pay. So it's not an unfamiliar exercise for valuers. They would prefer to proceed by way of comparables if there are comparables. But if there aren't comparables, then you have to reconstruct the sort of negotiation which will happen. And there was evidence about that in this case, a lot of evidence, to which cross-examination was addressed and on which the judge had to make up his mind.
And just to deal with the point, I think that troubled the court here at one point, I mean, just assume that this particular well had gone under, 100 different individually owned houses. How do you deal with that?
Well, what you have to do then, there is provision in the Act for that eventuality. The oil company can apply to the court in those circumstances. The court awards a figure. The figure is then paid into court, and then anybody who thinks he's entitled to can presumably come along and ask for his share. That does arise particularly in restrictive covenant cases, where there are a lot of people who are entitled to the benefit of the restrictive covenant. And somebody sues, and the court says, well, the development was worth so much, the release of the covenant was worth so much, but there are 30 people entitled to enforce it. So you, the one plaintiff who sued, only gets 1/30th. And that was applied in, for example, the case of Jaggard and Sawyer, the case in the Court of Appeal about trespass on a right-of-way to a house where there were, I think, 4 people who were entitled to the benefit of the right-of-way. So the damages recoverable by one of them was the amount for the grant of the right divided by 4. The courts have done that on a number of occasions. It arises in rights of light cases as well. I wasn't intending to trouble your lordships with those cases. They're a rather different field of law, but I can direct you to the relevant passages on Gale on easements, which deals with that topic, if your lordships would like me to. My lord, can I just stay with Pell Frishman for a moment? At paragraph 56 of Pell Frishman, Lord Walker discusses the judgment of the Court of Appeal and says that the Court of Appeal made an error of principle. He says the critical point was that the confidentiality agreements gave PFE a power of veto, which stood between its erstwhile collaborators and what they saw as a valuable opportunity. And the Court of Appeal didn't satisfactorily explain why it considered the amount of the damages, £500,000, awarded by the Royal Court for breach of confidence was too high, or its own conclusion that £500,000 was the appropriate global figure for the entire damages. And at paragraph 58, the Privy Council goes on to award $2.5 million as the appropriate figure. At the end of paragraph 57, Lord Walker says that where the Court of Appeal had said that the release of the obligations was nothing more than an inevitable and necessary concomitant of the loss of exclusivity, that was an error of principle. It brushed aside the continuing importance of those obligations, even though their value to PFE was a negative nuisance value. It significantly understated the commercial value of PFE's veto. So this was a veto case where the obligation which had been breached had a value, namely a release value.
Yes.
Well, my lords, that's the situation at common law, but I have not yet taken your lordships to the statutes. The first relevant statute is in volume 2 of the authorities bundle at tab 13. This is the Petroleum Production Act 1918. This act is not still enforced, but it makes part of the history. Prior to this act, one could simply have drilled down in one's land and extracted any oil you found. But Section 1 provides, no person, other than a person acting on behalf of His Majesty or holding a licence under the Act for the purpose, shall search or bore for or get petroleum within the United Kingdom, and if any person gets petroleum in the United Kingdom in contravention of this provision, he shall forfeit His Majesty a sum equal to 3 times the value of any petroleum. So there was a prohibition on extracting petroleum without Crown licence. Paragraph 2 provides for that licence, Section 2 rather. The Minister of Munitions may grant licences conferring authority to search and bore for and get petroleum to such persons and upon such terms and conditions as the Minister of Munitions may think fit. Now, this doesn't nationalise petroleum. It doesn't vest property in petroleum in the Crown. It just imposes a restriction. And then there's a proviso, which is important, provided that nothing in this Act shall be construed as conferring on any person any right to enter on or interfere with land for the purpose of searching or boring for or getting petroleum, which he doesn't enjoy apart from this Act, or shall prejudice or affect the rights, if any, of any person interested in any land in respect of petroleum gotten through or from the land in which he is so interested. So the fact that you get a licence from the Minister of Munitions doesn't entitle you to go on somebody else's land. That's quite clear at that point.
And the Act leaves it there, does it? Just hanging in the air, what you do next?
It does. It does. Apparently, very little use was made of this until 1934. The debates on the 1934 Act suggest that there had been negligible attempts to exploit onshore drilling in the United Kingdom before the 1934 Act, which is one of the reasons that the government advanced at that stage for nationalising oil without compensation. They said, well, nobody uses these rights, so it doesn't really matter. Whether that was a good argument or not is another matter, but I think there was quite a lot of, at the time of the First World War, I think quite a lot of oil was extracted onshore through oil shale, but that was a mining operation. I believe the British battle fleet in the First World War was partly powered by oil from oil shale, but not through deep drilling for onshore oil, which is a fairly recent departure. There are, however, now, I understand, some 40 onshore oil wells, a fact that I suspect most people would be quite, oil fields, which I think most people would be quite surprised to know, including in Surrey, as in this case. Well, that's the Petroleum Act 1918. That was repealed and replaced by the next statute in the bundle at tab 14, namely the Petroleum Production Act 1934. Now, this goes further than the 1919 Act. It repeals the 1919 Act in the section 11, and it then provides in section 1, the property in petroleum existing in its natural condition in strata in Great Britain is hereby vested in His Majesty. So oil is nationalised. And His Majesty shall have the exclusive right of searching and boring for and getting such petroleum. My learned friends place some stress on that second part of the section, so I draw it to your Lordship's attention. Now, before I go to section 3, which deals with ancillary rights, can I take your Lordship straight to section 10.3, at the end of this fairly short act, which contains a provision similar to the proviso we saw in the earlier act. Similar, but not quite the same. Section 10.3, nothing in this act shall be construed as conferring or as enabling the Board of Trade to confer on any person, whether acting on behalf of His Majesty or not, any right which he doesn't enjoy apart from this act to enter on or interfere with land. Perhaps your Lordships will note in passing the words to enter on or interfere with land. So, although the Act provides for the grant of a licence, this is section 2, by the Board of Trade, to search and bore for and get petroleum, it does not entitle you to go on somebody else's land to do so. The scheme of the Act is that the Crown owns the oil. The Crown can grant you a licence to search for, bore for, and get the oil, extract the oil. But the Crown can't grant you a licence to go onto somebody else's land to do that. And the Act does not grant you a licence to do that. But if you need a licence to do that, that's provided by section 3.
Could the Crown do it itself?
But the Crown can't do it itself, no. Nothing in the Act confers on any person any right he doesn't enjoy apart from the Act to enter on or interfere with land.
So the right of searching and boring would be confined to land, they carried out on land that they owned,
yes,
or had rented, I suppose.
Or obtained rights.
Or obtained rights over.
We say there are two quite separate things here. There's the Crown licence, which you have to have, because otherwise you can't touch the Crown's oil. And there's ancillary rights, which you have to acquire under section 3 if you want to go onto somebody else's land. You can acquire them, I haven't taken you to section
But
3.
you can't even go sort of prospecting around the country looking for where there might be some oil,
No,
unless you've got a licence from the Crown.
you can't, no.
You can't look at a map and think, well, this might be...
Well, you can do that.
Why can't you?
Well, you...
You're searching for petroleum.
Well, I don't suppose that the Crown would object to you going to
Well, no,
the records.
For the Parliament of it.
My Lord, I envisage that you can do this. You can go and look up in such records as there are, and there are records, to see what seismic data have been found by other people and put in the public domain. You can do that. What you can't do is go around letting off explosive devices to create seismic pulses to find out what's underground. And you can't start boring exploratory wells to see whether there's something down there. You can't do any of that unless you've got a licence from the Crown.
So searching is something that implies some kind of physical operation on land, not going to a public library and burrowing through books.
My Lord, I think it would be a rather extended construction to suppose it prevented you going to the public library. But you certainly need a licence if you start doing something on land or boring holes.
So section 3...
Section 3 gives you the right to acquire ancillary rights. And it says Part 1 of the Mines
Yes.
Working Facilities and Support Act 1923, which we need to go back to, as amended, shall apply for the purpose of enabling a person holding a licence under this Act, petroleum licence, to acquire such ancillary rights as may be required for the exercise of the rights granted by the licence, and shall have effect accordingly, subject to the following modifications. And B is important because it specifies some rights which are included in the definition of ancillary rights. It says, without prejudice to the generality of subsection 1 of section 3 of the said Act, that's the 1923 Act, the ancillary rights therein mentioned shall include, in addition to the rights specified in subsection 2 of that section, a right to enter upon land and to sink boreholes therein for the purpose of searching for and getting petroleum, and a right to use and occupy land for the erection of such buildings, laying and maintenance of such pipes, and the construction of such other works as may be required for the purpose of searching and boring for and getting, carrying away, storing, treating and converting petroleum. So the very things which happened in this case, searching and boring for and getting petroleum, are ancillary rights which you can acquire under the procedure in the 1923 Act. Now, while I'm on this Act, I must draw your Lordship's attention to some other matters which surface in the debate. Paragraph 2, section 3.2, made provision for any application under the 1923 Act to the Railway and Canal Commission to take effect subject to certain provisions. The Railway and Canal Commission until 1949 was the body which decided compensation payments under the 1923 Act. From 1949, that function was given to the High Court. Now, then A, B and C deal with certain matters. B says, in determining the amount of any compensation to be paid in respect of the grant of any right, an additional allowance of not less than 10% shall be made on account of the acquisition of the right being compulsory. Some stress is laid on that, both by the intervener and by Starr, to show that what we're dealing with here is compulsory acquisition. It's an odd provision, that, because the 10% additional allowance for compulsory acquisition had been abolished in 1919 by the Acquisition of Land Act, 1919. It was something that took place in Victorian times, but had been deprecated by the Scott Commission, which considered compulsory purchase legislation and abolished it in 1919, and it's rather strange to find it resurfacing in 1934. However, there it is. Little c deals with costs and says that the costs incurred by the applicant shall not be ordered to be paid by any person from whom a right is sought to be obtained. So the applicant is going to have to pay his own costs, and then there's a provision that says that I'll read it, unless the Commission is satisfied that an unconditional offer in writing was made by the applicant to that person of a sum as compensation equal to or greater than the amount of any compensation awarded to him by the Commission, he shall be ordered to pay, the cost shall be ordered to be paid by the applicant. So the applicant has to bear his own costs and is at risk of having to bear the other party's costs as well. So he does face, if he goes through this procedure, both the potential for delay and the potential for expense, which will probably encourage him to be fairly generous when he's negotiating in the first place.
This is all reenacted in 1966, is it?
No. This Act is reenacted in 1998.
No, you're quite right.
But
I'm
that's
sorry.
too late for presentation.
The other one,
The other one, the
23
1923 Act, is reenacted in 1966.
I mean, does this 10%, it still operates? Does
It
it?
still operates, yes.
I mean, how does this work with your submission? I mean, when they're doing this notional negotiation, you say you ignore the Act.
No, I don't.
Oh.
I say at common law, it takes place against the background of the Act. When we come to the terms of the Act, if a party goes under the Act, and I haven't taken you to the section yet, which deals with compensation, but if you go under the Act, under Section 8.2 of the 1966 Act, then the basis is exactly the same as at common law, so it doesn't make any difference.
How does the 10% work at common law?
Well, the 10%...
That's my question.
Yes. If it were not for the Act, the 10% wouldn't come into it at common law. If you are considering a negotiation against the background of the Act, one party would say, the oil company would say, if you don't do a deal with me, I will go under the Act. To which the landowner can say, if you go under the Act, you'll not only have to pay a reasonable price assessed on a willing grantor, willing grantee basis, you'll have to pay another 10% and all your own costs. So if I were you, I'd do a deal with me now. So that strengthens the position of the landowner. It doesn't weaken it, it strengthens it.
I don't understand, but you'll come to this, no doubt, how the 10% operates under Section 8 when we come to it.
The 10% doesn't operate under Section 8. The 10% is in addition to Section 8 compensation.
So you do your Section 8 exercise and then apply Section 3
And
to...
then add 10%. That's what the Act says. Which is strange because, as I say, the 10% solatium, as it used to be called, for compulsory purchase, had, in the rest of the compulsory purchase law, been abolished in 1919.
Anyway, it was unabolished for this purpose.
So it seems.
So when you said earlier on you're no worse off under the Act than at common law, you're better off because of the delay and expense, you're now adding in delay, expense, i.e. costs, and 10%.
My lord, that's right. Now, we didn't rely on any of that at first instance. We didn't place any reliance on that at all. We simply said, look at what two parties, willing grantor, willing grantee, fair and reasonable deal. That's all we're contending for. We didn't ask for any increase for what might be called the hassle factor, expense factor, delay factor, 10% factor at all. It played no part in our claim. We could perhaps have asked for a bit more, but we didn't. We treated that as just wrapped up in the 12.5% that we were seeking. Well, that,
Where's the 1923 Act?
the 1923 Act is
Volume 1,
at
10.
the end of Volume 1.
10. Tab 10.
It's tab 10.
No. Are we, it's been considerably amended, isn't it? I mean, I'm at the moment.
And it is not the Act which was in force at the time of our imaginary negotiation in the early 1990s. So the Act that matters to us is the 1966 Act. And I think it might be more helpful to go to the 1966 Act. I will refer to the 1923 Act because it gives us some of the history. But it's the 1966 Act which is the relevant one, as I think is common ground.
Where's that?
That is in Volume 1, tab 11, immediately after the 1923 Act.
Now, while you've been speaking, I've been comparing what you've been saying with the annex to the Court of Appeal's judgment,
Yes.
where we have the statutes set out in their amended form. Perhaps you can keep that in mind when you're taking us through the statutes themselves and point out where the amendments would be if we need to take them into account.
Yes. My Lord, I'll try to do that.
Ultimately, we perhaps might find it helpful to look at the annex and just see how it's presented there.
Yes, my Lord, thank you very much. It's very kind of you to suggest that.
Anyway, we're looking now at the 1966 Act.
The 1966 Act.
Yeah.
Could I just ask you something about the 1923 Act? Just looking at Section 1 of the 23 Act, would it be right to say that the danger of minerals being permanently unworked indicates this is a statute operating in what was then entirely the private sector,
Yes.
but a national interest that, in the interest of the national economy, minerals should be worked? I mean, is that a fair depiction of what?
Yes, my Lord, that is absolutely fair. What had happened was that during the First World War, coal, of course, was an absolutely vital commodity. And there was a parliamentary commission which sat after the First World War to deal with certain problems which had been encountered, which were inhibiting the development of the coal fields. One of those problems was associated with copyhold land. Now, this is all rather abstruse, but copyhold land had been enfranchised by the Law of Property Act 1922, which meant that copyholders therefore became freeholders. And they became freeholders, however, subject to the rights of the lord of the manor in minerals. And the situation which existed between the lords of the manor and copyholders was this: the copyholder had possession of the land, including the land below the surface. But the property in the minerals was vested in the lord. So the copyholder got the land, he was entitled to possession, the lord of the manor owned the minerals, very like the situation which obtains here, where Bocardo owns the land and the Crown owns the minerals. But the lord couldn't get at his minerals because he didn't have possession or any rights of access, absent any local customs to the contrary. And so you got a standoff in which one party could say, you're not coming onto my land to get at your minerals, and the other party could say, you can't dig the minerals out from under my land, under your land, because they're mine. That was one of the problems which the 1923 Act was designed to solve, as you can tell by Section 1 of the Act. Well, Section 1 goes straight to the copyhold problem. And it says, where there's a danger of minerals being left permanently unworked, by reason of the minerals being comprised in or lying under land which has been copyhold land. So that was the prime problem as far as the 1923 Act was concerned. But then it deals with other problems, as in B, minerals left permanently unworked by reason of the minerals being owned in such small parcels they cannot be properly or conveniently worked by themselves, and so on. There were different situations to which the Act was directed. But it was dissolved to free up the coalfields so that people could not obstruct access to coal under their land by saying, I'm not going to let you in unless you pay me an exorbitant sum of money to let you in. That was the background to it, and it conferred, as does the 1966 Act, the ability to obtain ancillary rights for the working of minerals, which is contained in Section 3. At that stage, of course, coal was not nationalised. Coal was a matter of private ownership. Have I dealt with your Lordship's question?
Yes, thank you very much.
Thank you. The 1966 Act says in Section 1, the Court may, subject to and in accordance with this Act, confer any rights described in the table below. And then we can go over the page to all minerals ancillary rights. I just note in passing that the rights to which this Act applies are not only ancillary rights, they can be a right to work minerals, and that is provided in the table immediately under Section 1 on the first page. It doesn't apply to peat, but it does apply to a right to search for or work any minerals to which this paragraph applies. So you can get a right to work minerals under the 66 Act, not merely ancillary rights. But ancillary rights are dealt with at paragraph 5 of the table, which provides an ancillary right may be conferred on a person having the right to work minerals, such as a person entitled to extract oil by reason of his petroleum licence under the 1934 Act, who is working or desirous of working the minerals either by himself or through his lessees, if the right is required in order that the minerals may be properly and conveniently worked by him, and the proper and efficient working of the minerals is unduly hampered by his inability or failure to obtain that right. And then ancillary rights are defined in Section 2, and among the ancillary rights, including a right to let down the surface, so that's a right to cause subsidence. In B, a right of airway, shaftway, or surface or underground wayleave, or other right for the purpose of access to or conveyance of minerals or the ventilation or drainage of the mines. So to get access to minerals, and if you need an underground wayleave, you can go under this Act, but these rights, of course, are in addition to the ancillary rights which is specified in the 1934 Act. Right to search and bore for and get oil. So if you need to go through somebody else's land...
If you need to do what?
If you need to go through somebody else's land, here is how you get the right to do it. Now there are limitations on the grant of this right, these rights, which are contained in Section 3. First, the court has to be satisfied that the grant is expedient in the national interest. In the case of oil extraction, I think we can take that for granted. Secondly, no right is to be granted unless it's shown that it is not reasonably practicable to obtain the right by private arrangement for any of the following reasons. And then there are 4 reasons. The first is that the people who have power to grant the right are too numerous or have conflicting interests. B, persons with the power to grant the right cannot be found. C, persons from whom the right must be obtained haven't got the necessary powers of disposition. And D is the important one. The person with power to grant the right unreasonably refuses to grant it or demands terms which, having regard to the circumstances, are unreasonable. So if the landowner asks for too much money, you can go to the court. But you have to negotiate first. You have to show that it's not reasonably practicable to obtain the right by private arrangement. And what you do first under section 4 is you apply to the minister. And he has to be satisfied that one of these grounds exists before the matter goes any further. And if you're going under D, then he has to communicate with the landowner before he gives the go-ahead. Now, if the minister thinks there's a prima facie case, then you can go to the court. But the minister is not necessarily all that swift at dealing with these matters. And if he says yes, you can go to the court under section 5, and the court, if satisfied that the requirements of the Act are complied with, may by order grant the right on such terms and subject to such conditions and for such period as the court may think fit. And then on subsection 2, where a right is granted, such compensation or consideration as in default of agreement may be determined by the court shall be paid or given by the applicant in respect of the acquisition of the right to such persons as the court may determine to be entitled thereto. And so one asks, well, what is the criterion for compensation which the court is to apply? And one finds that in section 8.2. The compensation or consideration in respect of any right, including a right to enforce restrictions, shall be assessed by the court on the basis of what would be fair and reasonable between a willing grantor and a willing grantee, having regard to the conditions subject to which the right is or is to be granted. So fair and reasonable between a willing grantor and a willing grantee. And that,
Compensation and consideration are the same thing, are they?
well, my lord, I suspect not. I suspect what they're thinking of is compensation is a word applicable, I suppose, to where damage has been caused. For example, one of the rights under this Act is the right to let down the surface.
The right to do what?
To let down the surface, the right to cause subsidence. And that might well require compensation. But other rights, for example, a right to extract a mineral, you'd expect a price for, which I think one would call consideration. I think that's probably the distinction now, that this price is sometimes compensation for damage and sometimes consideration for a valuable right which you're receiving. I would suspect that is why the expression compensation or consideration is used.
It seems to appear for the first time in section 5, subsection 2.
It does.
I think I'm right in saying.
It does.
And just while we're looking at section 5, the bit at the end of section 8.2, which refers to conditions subject to which the right is or is to be granted, I suppose is a reference back to section 5.1.
Yes.
Would that be right?
Yes, that says subject to such conditions. And so conditions can be imposed. By the court at that stage, and that may affect the amount of the compensation.
The expression is also in the 1923 Act, and it may go back much further than that.
Yeah, well, it does come from there. It's fair to say, and I think my friends make this point, that the expression in the 1934 Act is compensation, whereas in this Act it's compensation or consideration. Not sure what turns on that ultimately, but the expressions are there.
Well, I see that section 8 is entitled compensation.
It is.
Just to pick up another detail, if I could, the 1923 Act talks about minerals without defining them, I think.
Yes.
And the 1934 Act, Section 3, then applies the 23 Act to petroleum,
Yes.
which is defined. I see that the 1966 Act has a very wide definition of minerals as including substances. Does that mean it now applies directly to petroleum rather than through the mediation of another statute, or what?
My Lord, I'd understood it to apply to petroleum by virtue of the 1934 Act and then the subsequent 1998 Act, which otherwise would have been to some extent unnecessary.
I see.
But your Lordship's right. The definition of minerals, which is in section 14 of the 1966 Act, is a wide definition.
But it doesn't contain any reference to boring or other drilling operations.
What it does do, and this may be of some significance, is it does refer to minerals and substances in or under land obtainable by underground or by surface working. And of course, if one takes the example of coal, which is probably the easiest one, a coal is often obtained by underground working, which doesn't involve any penetration of the surface under a particular landowner's land at all, because the galleries are driven from neighbouring land. And so this Act would appear to be, as was the 1923 Act, applicable to a situation where you were coming in from the side, as it were, not coming in through the top. One of the points made against me is that the reference in section 10.3 of the 1934 Act to entry on land or interference with land is not applicable to underground working. Well, we say that can't be right, because these acts apply explicitly to underground working.
So 10.3, the phrase is enter on or interfere with land. Is it suggested against you that is simply surface operations?
It is
entering on the surface.
Yes, that is a point made against me. I say you can enter on land at depth by coming in from the side. And indeed, the ancillary rights which you could obtain and which are incorporated by the 1935 Act include the right to come in from the side.
So, have I got this right? So, on your analysis, is petroleum or oil, is that included in minerals or not?
My Lord, I think I must try and tie this down. My understanding is that oil is dealt with solely by the 1934 Act and the 1998 Act, replacing it. It may be that there is an exclusion somewhere relating to oil in the later acts, and I'm not quite sure whether that's right, and I must establish that for your lordships. The right to work, the right to bore for petroleum is only obtainable from the Crown. It is not obtainable from another landowner. So it must be right that, I think that's how it works. You've got to have your petroleum licence from the Crown, in addition to which you need your land licence from any landowner through whose land you wish to go. Under the Act we're looking at, the 1966 Act, replacing the 1923 Act, you can get the necessary land right, but that doesn't entitle you to go and extract the oil on its own. You've also got to have the Crown licence.
So this applies under the 1934 Act as the successor to the 1923 Act, does it?
It does. The 1966 Act, it is provided in the Act that the 1934 Act is amended so as to refer to the 1966 Act instead of the 1923 Act. I think we set out the relevant provisions in our printed case. I'm sure we do.
It's paragraph 30 of your case, I think.
It is indeed. And we give the schedules which have that effect.
Well, have we covered the statutes then? I
My
mean,
lord, yes.
is it worth just glancing at the annex? I
My
think
lord,
there's
yes.
nothing actually that I've spotted which conflicts with what you've been saying, but it gathers the stuff together quite conveniently, doesn't it?
Indeed. Yes, so we have the 1934 Act and the 1966 Act. My lord, I just check to see if there's any discrepancy. I don't think there is.
I think not. I mean, there are lots of fiddly bits of amendments which we can see in the head notes, but they've been built in.
In your note 15 to paragraph 30 of your case, you refer to the Schedules 1 and 2 to the 1966 Act.
Yeah.
But as printed in tab 11, they're in the form they are post the 1998 Act. Whereas we're not concerned, is this right, with the 1998 Act?
No.
Because that's why, because this postulated negotiation takes place earlier than that.
That's right.
Is that right?
That's right. On any view, it does.
And would it actually make any difference if it was post 98?
I don't think it would, my lord, no. In the Court of Appeal, the Secretary of State based himself on the 1998 Act, and Milena Friend and I assured the Court of Appeal that wasn't right. And it is now accepted by the Secretary of State in the intervener's case that it is indeed these two acts that we're concerned with, not the 1998 Act. My lord, I'm moving on to point 7, I think, in my structure.
Yes.
Which is a point I've touched on already, which is whether the 1934 Act permits entry at depth. It is Starr's argument in this, which is contained in paragraphs 93 to 104 of their printed case, that Section 1 of the 1934 Act gives them, by virtue of their petroleum licence, the right to enter my land, and that Section 10.3 does not take it away because Starr's conduct involves no entry on or interference with my land. We seek to meet that argument at paragraphs 133 to 139 of our case, and
133 to 139, was it? Did you say 133?
I did. I'm sorry, my lord, 133.
Yes.
And the Court of Appeal agreed with us about that, and their analysis, for your lordship's note, is at paragraphs 81 to 83 of their judgment. And we say they were right about that. Starr's position seems to be that sinking a borehole down through the surface of another's land does require an ancillary right, but doing so by way of a deviated well from your own land doesn't. nor presumably, would they say, would cutting an underground passage from land A through land B to get to land C require an ancillary right, because it's not an entry on the surface. This is a point which is taken on the pleadings, but was abandoned at first instance by Starr's counsel, and both in their skeleton argument and their opening, they said they weren't going to rely on that point. And in my submission, that was a wise concession, because it is a bad point. In paragraph, I'm so sorry. In paragraph 136, we give our answer. We point out that the right to enter upon land and sink boreholes is an ancillary right, which is expressly mentioned. The expression enter upon land is perfectly apt to apply to underground entry. The definition of ancillary rights expressly includes an underground wayleave, and the drilling of a deviated well from neighbouring land plainly interferes with land, and the expression is not interferes with the use of land or interferes with the enjoyment of land, it interferes with land. If we're right in saying that land includes what is below the surface, then an entry on land would include an underground entry on land. And as we've seen, access to minerals, which access is obtained by underground working, is contemplated by the statutes. So we say it is really quite clear under section 10.3 that there is a distinction here between what the petroleum licence permits and what the ancillary right permits. The petroleum licence is your permission from the Crown to look for and extract the Crown's oil. But that does not carry with it, because section 10.3 says so, the right to go onto other people's land to do so. That requires a second licence, which is a licence from the landowner, which, if he won't give it to you at a reasonable price, you can obtain through the Act by way of an ancillary right, as it's called. And the Act expressly provides that neither the Act nor the Crown can grant the right to go onto somebody else's land.
So, could you repeat that? The last sentence.
The Act expressly provides that neither it, the Act, nor the Crown, granting a petroleum licence, can grant the right to go onto somebody else's land. Section 10.3 says the Crown has no right to confer that right, and the Act does not confer that right. My Lords, we say this is not a case of ambiguity where it is appropriate to refer to Hansard. But if it were thought to be a case of ambiguity, we have given you in our printed case the reference to the relevant passage where the minister promoting the bill in 1934 made this very distinction explicit.
Paragraph 139.
It is.
I hope he made clear his conflict of interest. He was one of the largest owners of coal mines in England, isn't he?
I'm not sure that he did.
I'm sure he did.
Not in the passage I read. Well, my Lords, going back to section 8.2, which is the crucial section for this purpose, the one that says that the basis of compensation is what is fair and reasonable between a willing grantor and a willing grantee. the notion underlying that is, in my submission, the notion of a bargain.
Of the what, sorry?
The notion of a bargain.
Bargain.
A bargain between a person willing to grant the right and another person who wants the right. They're both willing. It's a fair bargain, not an extortionate one, but it's a bargain, not a gift. The fact that the grantor is deemed to be willing does not mean that he will take anything. It means willing at a fair price, if he is given a fair price. If he is not offered a fair price, he will not be willing. And the
That's circular, isn't it? I mean, he's deemed to be willing. You can't then say, well, if the price isn't fair, he isn't willing. He's deemed to be willing. So that's your starting point.
Yes, he's deemed to be willing, but to call him willing doesn't tell you what the price is.
No.
It simply says he is willing to do a deal, the other party is willing too, neither party are constrained, neither party are forced to the negotiating table by some extraneous factor. They both come there willingly. One wants to get to the oil, which will be worth whatever it will be worth to him. The other is perfectly happy to sell him a right to do it, but it will be a sale. It will not be a gift. It will not be given away, because he will have a notion, and he will get advice, as to what the value of that right, which he's being asked for, would be worth to the other party, and they will then negotiate. That is, in my submission, the underlying notion under section 8.2. Now, the other point I'd make in passing...
Is that the same principle? Or is that identified by, for example, Lord Nichols?
By Lord Nichols in...
Well, in Blake, or in any of the cases.
Yes, it is in fact, yes. It's no different from Blake, which is why I say it's no different from the common law, which is why ultimately I say the statute makes no difference. The statutory test is the same as the common law test for awarding damages on the user basis.
You say the only difference statute makes is it actually puts the seller into a better position than a common law, because he's got the whip hand, because if in fact this doesn't go through, then the other person, the person who wants the right, we've been through it, has all the delay, has to go to the minister, has to pay the cost, has to pay like 10% uplift.
Yes. That could be so.
Well, that's your case, that it is so. You have to say that.
Well,
Better position.
I don't hesitate to say that.
No, I know. Better position than a common law.
Well, yes, but he does, of course, have to grant the right, ultimately. It's not as though the statute is ineffective. The statute is effective to enable the mineral operator to obtain these rights, which he wants. He can either go under the Act, in which case a certain result is produced, which we've seen, or if he usurps the right without going under the Act and has to pay damages, then he will have to pay the common law measure of damages. He may be a little bit better off, actually, on that basis. But so if I then say, well, if we take into account the Act, that simply puts him back in the position he would have been if he'd gone under the Act. That's not a terrible thing. That's simply saying, well, you haven't gone under the Act, you should have gone under the Act, you must pay what you'd have had to pay if you had gone under the Act. That's all right. Before I leave section 8.2, can I just make this further observation, that it is a fact, what turns on it is another matter, but it is a fact that the compensation provisions in section 8.2 do not make any reference to the legislation on compulsory purchase. They don't make any reference in the 1966 Act to the valuation criteria which are embodied in Section 5 of the Land Compensation Act 1961, which after all was not that long before the 1966 Act. And in the 1923 Act, which was replaced by the 1966 Act, they make no reference to the valuation rules in Section 2 of the Acquisition of Land Act 1919. Now, this is in marked contrast to other acts of Parliament involving underground installations, such as, for example, the Pipelines Act 1962, the Channel Tunnel Act, the Electricity Act, the Gas Act. All these acts do confer rights to obtain underground rights on the basis set out in the Land Compensation Act 1961, but not this Act. So I don't want to press this too far, but my point is that this is not an Act which incorporates the usual valuation criteria for compulsory purchase. This is a standalone Act which is outside the usual compulsory purchase legislation and contains its own valuation criterion, which is fair and reasonable between willing grantor and willing grantee.
Is there an explanation for that? I mean, I can see the picture you present, but is there some sort of underlying philosophy behind this? The problem is that ultimately, because you can go to the court,
yes,
you can actually, if you're seeking to obtain this right, you can get it compulsorily.
Yes,
so
yes,
I would
indeed.
have thought there was an affinity with the compulsory acquisition principle.
Well, my lord, I have to accept that there is a right ultimately to go to the court and get the right compulsorily. Where one goes from there is another matter. Anticipating really my later submissions, my suggestion will be, and I hope it's a reasonably moderate suggestion, that the right approach to this Act is to take the terms of this Act and apply it according
Because under this Act, you get an extra 10%, do you?
Well, under this
And
Act,
that itself is contrary to Section 5 of the 1961 Act.
It is, yes.
Which expresses says no allowance shall be made on account of the acquisition being compulsory.
Yes.
So it can't obviously apply by statute.
No.
There is a sentence in your printed case at page 28. There's a fundamental distinction between an act which gives a public authority a right to acquire property and one which regulates property rights between private parties.
Yes.
Now, does that distinction, does it stand up? I mean, if it does, it might be a good point.
Again, I wish to approach this with some moderation because I'm aware, I'm sure everybody is aware, that the Land Clauses Consolidation Act 1845, of course, the parent of the whole compulsory purchase legislation, was largely concerned with private railway and canal companies. Since those days, of course, a lot of compulsory acquisition is at the behest of public authorities, although in recent years perhaps the pendulum has rather swung back because of privatization of various public authorities. I don't think I can maintain that there is a hard and clear distinction between compulsory rights which are enjoyed by public authorities and compulsory rights which are enjoyed by private companies. It would be going too far.
I'm sorry to interrupt you. I was going to say it's partly privatisation and it's partly an extension of the purposes for which Parliament thinks it proper compulsory to acquire property, isn't it? Urban regeneration, all that.
Yes.
I mean, we had a case recently which was basically a battle between Tesco and Sainsbury. It was not involving public interest, except so far as the regeneration of the centre of Wolverhampton was a matter of public interest.
Yes. Well, of course, public authorities very often exercise their powers of compulsory purchase to assist private developers put together a site which can then be developed for a purpose which is seen to be of benefit to the public for some broader reason of planning. So, my Lord, I'd agree with the point your Lordship made.
But what we'll be looking for, surely, is some coherent, some cogent basis for treating compensation in this, under this statute and in this respect, completely differently from all other compulsory purchase scenarios.
Well, my Lords, the best I think I can do is this, that there are, of course, quite a large range of rights.
Range of
rights.
rights.
Which you can acquire under the 1923 and 1966 Acts. In particular, under the 1966 Act, as we've seen, you can acquire the right to minerals. Indeed, you could under the 1923 Act. The coal has now been nationalised. Certainly in 1923, you could have acquired the right to mine coal. Now, it may have been thought that there were some technical difficulties, I don't know, in applying the compulsory purchase code directly to this Act, which dealt with all sorts of different rights: a right to acquire a mineral, a right to mine a mineral, a right to let down the surface, a right to get access to go through land to get a mineral. It may have been that there was some difficulty seen by Parliament or those advising Parliament about applying the code to that wide range of different rights. I simply don't know.
I suppose you can say, well, the code, after all, is something that was created by Parliament. It's not a common law.
That's right.
Principle, and Parliament can make its own choices. And one knows that when it's applying the code, it's set out on the face of the statute. There's a well-known formula which one can see, and it hasn't used this here,
No,
and therefore it's a choice that Parliament made. But I mean, to say there's a fundamental difference, maybe pressing the point too far. You have in the same paragraph the point I think you just looked to see what Parliament has set out.
Yes.
And maybe that's as far as you need go. And the language
Well,
is different.
I think it is as far as I wish to go, because I think one has to be rather careful about saying this is not compulsory purchase because it doesn't invoke the usual compulsory purchase code.
But it's not said, is it, that Section 5 of the 1961 Act applies on its true construction?
No.
It's said to apply somehow by analogy, or so we
well,
can't turn to a statute and say, well, here is a statute which applies. I mean, this is not a compensation in respect of any compulsory acquisition within the meaning of Section 5, is it? Or is it?
No. What is said, my Lord, against me is this. It is said that in the development of the law of compulsory purchase, a principle was created by the courts before the code in the 1919 Act and the 1965 Act, known as the point good principle, after a case decided in the late 1940s called point good. And the point good principle has been considered by your lordships in recent cases and held to have survived the codification of compulsory purchase law in the 1919 and 1961 Acts, so that it exists beside the various complex assumptions and disregards and so on provided in those Acts. Now, I know that at least three of your lordships will be very familiar with this part of the law because you have been involved in the case of Waters and Spiros. And the point good principle has been held to survive as a principle of construction of compulsory purchase legislation beside the compulsory purchase code in the Acts. Now, what is being said here by Starr is that point good applies here, despite the fact that this is not a case to which the Land Compensation Act 1961 applies. And what is said, and I think the way it's put by Starr is it applies by analogy. The Secretary of State intervening goes further. The Secretary of State intervening says it doesn't apply merely by analogy, it applies directly, because this is a compulsory purchase statute. That's what he says. And what I say is that it's all rather missing the point, because those statutes and that code is not incorporated here. But what we do have here, and I can't get away from this, is the words fair and reasonable. Now, the point good principle is essentially a presumption against overcompensation. It says landowners can't get more than what their land is worth. They can't get more than the value of the land to them. I say, I don't have a problem with that. Here, we're told expressly the compensation has to be fair and reasonable. So I don't need a presumption against overcompensation. This section provides expressly against overcompensation. But what I do say I have is a bargaining position. That's part of the value of my land. It's preserved for me by Section 10.3 of the 1934 Act. It's something that enables me to deal with, to bargain with, the oil operator who comes along and asks me for a way leave through my land. And that is part of the value of my land, and it is not overcompensating me if I'm given money to compensate me for being deprived of that bargaining position by the Act. It is a bargaining position I would have apart from the Act.
I mean, has the point good principle been applied, if you like, to the assessment of damages in this area at common law outside the role of compulsory purchase, or outside the case like this where there is some relevant statute?
No, Lord, not as far as I'm aware.
And in valuation for rating, it would be a nonsense, really, if to apply it there, wouldn't it?
In
valuation for rating, I'm thinking of, the sort of, the kind of valuation exercise where one's commonly adopting the willing seller, willing buyer approach.
My Lord, that's right. And I mean, I can think of other examples of what might be regarded as compulsory purchase provisions, quasi-compulsory purchase provisions. For example, the Leasehold Reform Act, 1967, which enables a tenant to buy the reversion by his landlord's interest, in reversion on a long lease, from his landlord. And the similar 1993 Act, which enables tenants of flats to do that. Now, they've got a right to acquire interests by compulsion, but nobody's ever suggested point good applies there. And the reason is, of course, that there's a quite separate code, quite a complex, detailed code, for carrying out valuations under the 1967 Act and the 1993 Act. It's very dangerous to simply say, well, because that principle applies in cases to which the Land Consolidation Act 1845 applied, and to which its successor statutes apply, it's very dangerous to say, therefore, it must apply here. It would, my respectful submission, be a rather rum approach to statutory construction to say that. I'm aware that your lordships have held in the Spirose case that the point good principle is a general principle of construction, which, as I think my Lord Collins said in that case, is primarily directed to the word value in the Land Clauses Consolidation Act 1845 and its successors, because that act simply said the landowner is to be compensated by getting the value of his land. But here we have different wording, which, as I say, makes it explicit that the landowner is not to be overcompensated by the words fair and reasonable, where we don't need point good to do that.
So I thought you actually say that the value of his land does include this bargaining value.
Yes. Yeah, I do say that, yes, absolutely.
But point Gord says you must ignore that if and insofar as that value arises only from the reason why the land is being acquired.
From the scheme of compulsory acquisition, whatever that means. Yes. Well, again, it's anticipating things, but I say that that value does not arise from anything to do with the fact that Star Energy may be able to acquire compulsory purchase powers or a right of compulsory purchase. The value arises from the fact that my land is sitting on top of the apex of an oil field, which is the point at which the oil operator needs to target his oil well in order to extract the maximum amount of oil. It's a geological and geographical feature which gives my land its value. It's got nothing to do with any scheme of compulsory acquisition.
I mean, is there any useful analogy that you can give in respect of the compulsory purchase situation in terms of pre-existing key value,
Yes.
premium value, ransom value, where the various terms are used?
Yes, my lord, there is.
What is it?
Well, it is exactly what I've just said. The pre-existing value is there because my land is on top of the apex of an oil field.
But I'm sorry, just assume...
It isn't created by the grant of the petroleum licence to Star. It's there already.
Well, just assume that Star weren't in the picture, but the local authority wanted to purchase your land, or purchase this right to access your land. I mean, with you know, for their own, they wanted to build a road or something. I mean, you know, just assume it's a classic compulsory. So are you saying they would have to pay for the ransom value that you have because some future oil company might want to? Is it a pre-existing key value in respect of a future oil acquisition?
If somebody wanted to purchase my land at a time when it was known that it was sitting on top of the apex of an oil field, and that it was likely that an oil operator would wish to have access through it to get to the oil, then that would affect the value of my land, yes. Obviously, those factors would have to be known about for it to affect value. But if they were known about...
I'm not quite sure I fully understand that. Supposing all that was required was acquisition for a road on the surface.
Yes.
The fact that there might be oil away down several hundred metres below wouldn't actually have any effect on the surface.
My lord,
use of the
if
land
all the
at all.
acquiring authority wants is a surface strip,
Yes.
which doesn't carry with it any rights to the subsoil, no problem. The value of the surface strip is not affected. And a highway authority, as I understand it, acquiring land for highway purposes, does only acquire a surface strip. So the highway authority is perhaps not the best example. But suppose they wanted to acquire the whole of my land to whatever depth, and it was known that the land had this potentiality and that it was sitting on top of an oil field, and that it was the route to get to the apex of the oil field. If those facts were known, then it would affect the value of my land, certainly. I would not be willing to sell my land unless those factors were reflected in the sale price. Because if I kept my land and waited until the oil operator came along, I would get a much bigger price. I mean, perhaps one can contest it by the more familiar example of the ransom strip. A bit of wasteland 3 yards wide beside a road from which the developer of some backland for housing, across which he can be expected to want to obtain access, there being no other suitable available access. I'm sitting on my ransom strip. The developer has not yet appeared, but the backland's there. I know that there is a potentiality there for it to be developed. I wait. I don't sell it for £10 or £100 or £1,000 because I know if I hang on to it, the time will come when I'm likely to be able to get a much, much bigger price for it. So I keep it. It is worth much more than the £100 that it might be worth on a per acre agricultural value. I hang on to it because it is worth more. When and if the developer appears, he will offer me the price. There may be more than one developer. They may compete to acquire this right. That is what gives my land value. Its geographical proximity to the development site, the potential development site. And so if I have a geographical proximity to an oil field through which the best access, perhaps the only access, can be obtained to the oil, to the maximum amount of the oil, that gives my land value.
Well, shall we continue this interesting discussion at 2:00?
Not all, of course.